I like your jumper. I like your jumper. That's cute. This way. They were gonna meet in Tia's office because they're using these up.
No worries.
That's in the room. You been doing alright?
Yeah.
Yeah.
Hi. How are you?
I'm good. How are you?
Okay.
It's always a little warm in this office.
Oh,
I'm
yeah.
sorry if it's a little warm.
Oh, no, I like it. It's comfy.
I forgot how warm it could get.
It's that window, if you can believe it, because the heaters aren't on.
Yeah. Pull up my little folder.
So, we wanted to meet with you because we're coming up on your pretrial, right, next month. And so the purpose of the continuance that the judge had given us was for us to have the doctor meet with you and do the evaluation, right?
Yes, and I got a neurologist.
Okay, perfect. So thank you for coming and coordinating with Patty for that evaluation. Dr. Morrison said that you were very forthcoming, very cooperative, that it was a good session with him. So thank you for that. After the evaluation, he reviewed all the medical records, and then we had a conversation.
Good.
And
Did he write a report?
No, not yet.
Okay. We'll wait for that.
Yeah, and so he indicated to us that he, as an expert, is unable to support our position on insanity defense.
Right.
So
No, I'm not insane. I don't want an insanity defense.
So, yeah, so
I parked my car, had a seizure, and they arrested me for having a seizure.
okay, because we had explored.
They told me to stop having a seizure.
Mhm.
3 times I heard it.
Mhm.
So this is about them arresting somebody for having a seizure instead of not cuffing me and helping me while I'm having a seizure.
Mhm.
And they did nothing. They laughed. They mocked. And it's unacceptable.
Well, I think that I don't think that's a recognized offense.
Well, we'll see the video.
Right. It's not a recognized offense in the sense that, like, with insanity.
I don't want an
we can
insanity
point-
defense.
Well, we can't do insanity anyway.
Well, so
right?
why
I'm
are we even
giving-
talking about it?
I'm giving you
You
an
asked us
example.
for it.
No, I didn't.
You did.
I'm giving you.
No, I didn't ask you for insanity
I'm giving you an
defense.
example. So, in the law, there are recognized offenses, like, self-defense. Everybody in the world knows self-defense.
Oh, I've seen battery on officer videos for
right,
sure.
Right. So, insanity is something like that too, where if we thought it fit the criteria, we would have been able to prove certain
No,
things.
we don't need to
got
prove
it.
insanity.
But the doctor
We
is
need to
saying that it
prove
don't fit it.
This isn't a crime.
So
I shouldn't have been
So what
charged.
you're saying is that you don't like the charge.
No, I don't not like it. It's unacceptable.
So you're saying
It's
it's
a false
unacceptable,
charge.
but what you're saying is
It's a
that
negligent charge.
you had a seizure. They arrested you for having a seizure.
Correct.
I think looking at the video,
They even say, I'm having a seizure. Are you okay? While I can't breathe.
Looking at the
they
video.
walked away.
Okay,
Did
listen.
you watch the video?
Yeah, I did. Listen, looking at the video, I think that a jury could look
I think
at
the
it
jury could see it
and
two
think
ways.
that you might have been having a seizure. They mentioned you're
Well, I
convulsing.
did have a seizure.
But that's just not a defiant defense. That's our reason. We can argue
I wasn't
that they were
pulled
wrong,
over.
but you just need to understand that's not like a defiant defense.
Sure.
We can argue that they
It's
were wrong.
definitely unorthodox.
And all she was doing was having a seizure and they arrested her. We can certainly argue that.
That's
and it
the argument.
matches
That's the
their
argument.
evidence. It
I don't
matches
care about
that.
their evidence. They have to prove.
No, but it matches their evidence, so it's a good thing to argue. I just wanted you to make.
Well, no, I know what the evidence is. I know what happened. I
it's
have
not
everything
a legal
documented.
defense, but it's
I
something
do want to
to
show you
argue.
something from the neurologist. Did you get it from my email?
That's what you sent me
Today?
Yesterday?
fresh? Yeah.
So this is it.
Right.
Now,
And this shows you.
what does this show?
This shows you in the first sentence. It says diastematomyelia and cortical dysplasia with seizure disorder.
So I have a question
So
for
look
you.
those two up,
Right.
and that he'll do a
what-
deposition.
well,
He's
hold on.
happy to do one.
Sure. So
and
I
I sent that.
I have a question for you because this is an EEG report from
I've
an
never had
EEG
it, yeah, mhm.
that you had. Okay.
Uh-huh.
Because I saw that it mentions
Because-
seizures here, right?
Because-
and it's in your past medical history.
No,
Yeah. So you
he's
said,
doing a brain MRI scan.
Okay. because right now it just says past medical history.
Right, from yesterday.
So,
Yeah,
right.
past is yesterday.
Well, no. So
Yeah, the past is 1 minute ago.
I mean, you're right, it is, but
Yeah.
this is referring to
The past.
what was reported to him.
So this is what we're trying to figure out, because certain things, like the judge won't allow us to have some random doctor just come in and say something.
He's not a random doctor.
You can say
he's my doctor, and he's a neurologist.
Okay, listen, he can be a neurologist, but there has to be a link to the crime. So unless we could show that historically
there
on
is
that
a link
day
to the crime.
you were
I had a
having
seizure.
But if that paperwork don't say that, then that's
Did I have a seizure disorder? It does
doesn't
say
matter
that.
if you have a seizure disorder. They have to show
What do you
that
mean
you were
it
having it
doesn't
on that day. You're not having a seizure
have a
right now.
disorder.
So if you just smacked me right now, you having a seizure wouldn't be a defense, right?
Well, that's because I'm not having a seizure.
Right. So we need to.
We have it on film, and I had a seizure.
It looks like you were having a seizure.
Right.
Well, they said I'm having a seizure. They also
But
asked what's wrong
if
with
we
you.
give them
Are you okay?
paperwork that don't say it, then that kind of takes away our argument.
I got it. It says it right there.
But it don't say you were having it on that date.
Right.
Oh,
You see
is
what
that
I'm
where
saying?
you're at?
So I don't want to take away the argument, because it looks
Yeah,
like
I have
to
medication.
a normal person, it's going to look like
that
you were having a
toned it down.
seizure.
Yeah, I did.
Right.
PTSD.
So I don't want to take away from
It's
the
a
argument.
PTSD cop thing. That's where the cops come in.
And your testimony can explain that.
Right.
But you get what I'm saying? Like, I don't
For
want to
sure.
call this neurologist, and this neurologist, when they pin them down, they're going to say, can you say for sure she was having a seizure on that day?
Yeah,
and he
can.
can't.
He can't.
Yeah, he saw the
There's
video.
no way that he can.
He saw the
You
video.
can't look at it and just tell.
Yes, he can. He's a neurologist.
Yeah, but you can't. My kid has seizures.
Are
He
you a
goes to the
neurologist?
My kid has seizures. He has a neurologist.
You don't know that
You
he's had
can't look
seizures.
at it.
Maybe he's not having a seizure.
No, my kid has
No,
one.
maybe he's not having
Well, maybe
one.
he's not
Maybe
having
he's
one right
not
now.
having one.
But the thing is
Is that your
you
argument?
don't want your doctor to mess up your case.
Right.
It has to be
No one's going to mess up my
say
case
it.
with my defense attorneys at this point.
Okay.
You don't want to go over the video.
If you don't want us on the
to.
case, you can tell the judge that too.
I want you to want it. I want you to want the case.
I mean, we
I want you to
do our
stop
job.
worrying about the DA's office and saving face.
Well, we don't care about the DA's office. We care about you.
Good.
How many trials have you gone to?
0.
Okay, so we're trying to prep
I've
you
always
for trial.
buckled, and this isn't going to happen.
We're trying to prep you for trial.
You're
We don't want
prepping
to
me
continue
about
on
telling
the
me
same
that this is
thing.
not an insanity defense, which I knew from the beginning.
Well, you asked for that.
No, I did not.
You might not remember it,
No,
but
I
we
didn't
only
say-
pursued it.
I said
to
I
pay
had
money for a doctor.
I have
because you wanted
documented
us to.
schizophrenia with behaviors of that.
You emailed me the insanity defense statute and said you wanted that.
I did show you that
Right.
And so we
initially,
tried to pursue
but you
it,
didn't
and
want
we
to
can't
seal
do
the
it.
case. You didn't want to seal the case.
The
I want a motion for this
case.
case to be sealed. I wanted a motion for the case to be dismissed within 30 days. That wasn't even offered.
That's not a legal motion we
There's
could
no
file.
basis for
Yeah.
dismissal.
Well, you always file one.
I mean, we're not like frivolous lawsuit filers. We're
Right.
attorneys with a
Your
bar
attorney's
card,
trying
but we
to
have
get people
only
that are not guilty
file real motions.
acquitted.
We have
For
to file
charges?
real motions.
Well, a real motion would be to ask for the case to be sealed because of HIPAA violation, and it cannot be public.
A case can't be sealed while it's pending,
Right.
so that's something you can handle after.
We
everything's said and
can
done.
seal a case while it's pending.
That's something that has to be done when it's, this is a public courthouse.
Right. So is
Courtroom.
family law.
It's not gonna be
That's
sealed.
also public.
But we're not family law. This
Right.
is criminal.
I understand, and it can be sealed.
So bottom line,
You guys don't
today,
wanna ask.
the reason we want to meet
Yeah,
with you
that's not a
today
motion.
is we wanted
What?
you to be clear that we can't do the insanity defense,
I already said that 4 times.
which is
We know
something
that.
we thought you were doing. You
No.
wanted us to do.
No,
We
I wanted
can
you to know that I have
argue-
medication. Sometimes it's a PTSD. It's already written. It's in the first paragraph of that document.
None of the stuff that you gave us so far is admissible.
My medical records aren't admissible.
They're not admissible.
Good. This is not admissible without a deposition.
That
I
has
could-
nothing to do with depositions. It's just not admissible.
Of course, it's admissible.
We don't believe that he is a witness who can testify to what you want him to, and even if he could,
I don't want him to testify
it's
to
not
anything.
necessary.
I just want him to show y'all that I don't have any other medical condition except for 2 spinal cords, 2 separate Duracex, and 2 separate nervous systems.
But you don't have to convince us of the
Also,
whole medical
the
thing. What we're arguing to the jury is that you were having a seizure
Because
at
of the
time
police.
the video, and they can see it. They can
Right.
see the video.
Yeah, so you're agreeing I'm having a seizure now, all of a sudden?
I think that's
No,
the best evidence.
We have not been disagreeing with you from the
Right.
beginning. We're
I just think
trying
the
to
video is the
explain
best evidence
how to
of that.
present that.
That's what it looks like to us.
I
Let's
don't
look
need you
at
to
it.
tell me how to present it. You guys are attorneys. You guys
We're
present.
telling you how we're going to present
Right.
it, and that we're not going to call this doctor or another doctor to say that this video looks like a seizure, because anybody looking at it can see that it looks like a seizure.
Well, this doctor can show you that my brain has different types of neurons. It's never been written before.
Yeah, that's not.
Never been written before.
That's not.
You know what they're called? Bizarre neurons. Was my behavior bizarre? Yes.
I agree with that. But that's not something that
I don't have to prove anything. All I have to say is I have condition that made me have that seizure. I don't have to show any medical records.
Right.
I don't have to say a freaking word.
We agree with that. We agree with not showing the medical records. I think you might want to testify, but you don't have to.
I still want to seal because it's on video, and that video camera shows me having a seizure, which is medically protected.
Okay, so after the end of the case, that kind of stuff can be sealed.
Fair. Then you can do that. Yes.
After the
Say
case
yes.
After the case is concluded, then we can look into whether.
Oh no, we're asking. We're asking. It can't be concluded, and then you didn't ask, so now it's not. Now it's not.
I mean, that's even something you can ask for yourself. You don't need a criminal defense attorney to do that.
Well, I'm not my lawyer on this case, so I can't send any forms. I can't file anything. You have to file it.
That's not even something that this lawyer would do. Like, if you got a not guilty,
you are my lawyers.
But if you got a not guilty and it's over, we're not your attorneys anymore. You're not charged with any crime.
That's why I want you to file it now.
That's not something we typically do.
I know you never typically do it.
But that's something you do after.
Do you want me to fill it out for you and then you just sign it?
No. That's something you don't need us. You don't need a lawyer.
You don't want to seal this for your
lawyers
lawyers?
and do it by themselves.
Still a case you can read. Still a case that's open to the public. Still video people can get. So no.
So after the case is over.
So if this was you, that's what you'd want?
After the case is over,
you'd wait for the case to be over?
You have to. And if you don't, anything that you want us to do that we don't do, you bring that up to the judge. Right. You keep a record of it, because if you lose, that can be grounds for appeal. And you have to keep a record of the things that you want that we don't do, or maybe things that we do that you don't want us to do. Right. That's just something you have to do in every case. So that would be one of those things that's on that list.
There.
But I think we agree that the best argument is you were having a seizure, they arrested you anyway, and it looks like that, and I think that's a good thing. Now, the other thing that you have to think about, we're just going to pretrial, and you know, nothing's really going to happen at that date. He's probably going to set it for trial. But you have a right to testify, and even if we think you should not, like we're like, no, you're going to do bad, you shouldn't, you still can. And even if we think that...
No, I'm not going to say a word.
Even if we think that
I'm not going to say a word.
And you
I'm not saying a freaking word.
Even we think that you should, and you don't want to.
Even if you wanted me to, I wouldn't.
I think that you should.
I think you should.
So I think you should think about it.
Then I will not.
I think you should think about it, though. You got a lot of time. And during the trial, it's going to come a point where you'll hear everything that they said. And then you'll see
Everyone has
evidence.
access to what the video is. I have it on my website.
You'll see what the jury sees.
I have it on my YouTube.
You'll have everything that was presented.
All my collections.
And you're the last person. So I always tell people this. If there's something that you wanted to come out that did not, like if there was like nobody mentions the
Morton Plant videos
or something,
right?
Then
I want you to get those.
You might have to testify to do it yourself. But even then, the judge will talk to you one-on-one. We'll be there, and he's gonna make sure whatever decision you make to testify or not, that is your decision. That we didn't make you or we didn't stop you. And so that's something that the right to go to trial and not plead, and the right to testify or not testify is absolutely yours. It's not our strategy. So I just want to
understand that. Yeah, absolutely. Yeah. I know that.
And so that brings us to the other thing. If you want to make a deal, even we're preparing for trial, we're ready for trial, and we're saying, you know, we think this is a good case. We're going to argue that you were having a seizure.
Principle.
If the prosecutor offers you something, you want to take it, we can't stop you from taking it. Or if you wanted to offer them something, even if we didn't think you should,
have to come with restitution.
we would have to offer that too. So that's something else that I want you to understand too, because I feel like, correct me if I'm wrong, Stephanie, but I feel like the judge kind of took issue that you didn't take some kind of deal in the past. Yeah. So sometimes he puts pressure. So this pretrial, even though it's just a pretrial,
you can pressure me. It was a reverse psychology. I really didn't care.
It'll probably be something like that. He'll probably get an attitude if he don't.
If he wants to make it longer, because you waived my right to a speedy trial right away without asking me.
If he doesn't already have, an attitude that day, he might get one.
I don't care what the judge's attitude is biased already. It's already documented. So what we do have documented is our first hearing, which was the one you didn't expect me to come to. So that in itself, the one that I actually said to them, well, intentionally, and then the judge told me about how intentionally could be perceived, and then I said, well, okay, I'll take the deal. And he said, too late. And I said, okay, because I bluffed him into that, and I'll see you in court. And I looked at the DA, and I said, you guys should have called an ambulance. This is not to teach me a lesson, because if they let me out, they said, she might be in the street in 24 hours. She would just be let go in a couple of days and be in the freeway. So it's been a year. I haven't been in the freeway.
Do you have any issues with...
I want the documentation from that minute. I want the minutes from that statement, from that hearing, revealed to the jury. I want the judge's statement. I want the DA saying she's totally fine, she's not injured, she didn't need help, and she doesn't want any restitution. I also want the video repeat, I'm fine, no honey, I'm fine, 3 or 4 times. She's fine. She does laugh, make fun of me for peeing my pants while I had a seizure. Other than that, I want to know who Pat is, why is he on the scene, and then what did you find out? I
don't understand. I know what you say about the hearing, but all the other stuff about I'm fine. When did that happen? You talking about that's at the scene of the crime?
Yeah.
Okay. I was confused. I thought maybe that happened at the hearing too.
No, she said she was fine, like 3 or 4 times on camera. Also, they don't want any restitution. She didn't even go to a hospital or a doctor, and she's not injured. But they're still calling it battery. Personal. Intentional. The first word when I read that statute is the word intentional.
Right.
So, hello?
Yeah.
Was that intentional?
Right.
Did you just watch me almost die? Having a grand mal seizure in front of you, and you're like laughing and sitting aside and got her on the ground, and I turn over and I'm still spasming? Stop. It's like telling someone to stop having a heart attack. Do you agree?
I mean, the video
Do you
shows
agree?
it all. The video shows it.
Do you want me to tell you to stop when you're choking on a bone?
No. Right. I think that's a good argument.
Heimlich would be good.
Yeah.
Hold me. You're okay. You're okay. No reassurances. Nothing.
Now, why don't you want to testify?
Why should I? They want to be big and bad? Show it.
What do you think caused the seizure, the PTSD, right?
I believe so.
Okay. I mean, they might not need to know what caused it because it looks obvious, right? But if you think, when the trial is going on, if you think you'll be to pay attention to the jury alive, if you think they have questions as to something like that, you're the only one who can testify.
There's only one 2-hour video.
You're the only one who can kind of explain.
You guys are the only one who are deciding to play it or not.
Well, I think the state is going to play it.
Yeah,
the prosecution is going to play it for sure.
Yeah. Fuck yeah.
They don't. I don't think they had the same read of it.
That's all they got. That's all they got. Is their stupid proof of themselves treating me like shit.
Do you have any?
And then charging me with a felony
for
having a seizure.
Any schedule conflicts or anything?
I will never have a conflict for this principal thing. I will never have a conflict.
No, I meant as far as when we set it for trial.
I will never have a conflict of anything.
Okay.
No dates when you wouldn't be available.
I have no dates that I would never be available.
Okay. All right.
First date. The first one. Okay?
And so
we'll decide at the time if I speak or not.
What he does is he'll set us for a calendar call date.
Yep.
And a trial date.
Yep.
And the calendar call date is just kind of everybody who's set for trial for the following week, and then on that day, he'll, some people will be like reset, some people do this, some people do that, and so then we'll know.
They might need to read the medical records and need more time, so they might prolong it. That might happen at pre-trial.
Well, there won't be any medical records, right? Because we're not.
Well, we have this.
We're not presenting them.
And you have all those medical records.
Yeah, we're not presenting any medical records.
Yeah.
For the seizure?
No, we don't need medical. We're not trying to prove that you have a seizure diagnosis. We're arguing you had a seizure at that moment. Believe your eyes.
Oh, no. Because their argument would be she's faking it.
I mean, they're definitely going to.
That's why we have to show that I'm not faking it.
Yeah, but this doesn't.
This is the only doctor that will do a deposition. My general won't do a deposition, and your guys' lawyer won't do a deposition.
You talked to him about it?
He asked me to do a deposition. I didn't ask him shit.
Who asked you?
The neurologist.
The neurologist?
I mean,
he's a specialist. He's well known.
We can talk to him to see.
I wouldn't mind if you asked him. But it couldn't hurt.
This is what we can do.
At least I've got a backup plan B in the box.
We can have our investigator talk to him.
That would be great.
To see if we should list them. And
that would be great.
If we list them, the state would depose them, and we'll read the transcript, all of us.
That would be great.
You think
just
that
this one guy, and then you can decide. Okay. But at least I'm gonna have a piece of science behind my ailment of my congenital dysphoria deformations. You know what I'm saying?
Right.
And it is all congenital.
Some jurors might want science.
Well,
right?
There's got to be a reason behind it, or it's going to be fake, because they apparently, the forensic psychologist said, some people do fake it, and I'm in jail a lot, and I see a lot of girls faking seizures, and the cops see it too. So I understand the cops may be thinking that,
right.
And I also want to show that, there is the forensic scientist also said, psychiatrist also said that he's noticed an uptick? Mm-hmm. In the batteries in this jail, of law enforcement batteries. He's noticed that charge comes up a little bit more lately, a lot more. So they're writing more of those tickets, which are unfounded. I mean, no one's going after that cop like cops that I see on videos of battery of cops. I had a seizure. They didn't care.
Steph, who's your investigator?
Rod.
So that's where I'm just so passionate about it, because it's a health issue.